Getting divorced can be a horribly stressful experience. Emotionally, you will be dealing with the end of your relationship, and this can be difficult even if it was your decision to end the relationship. It can often be extremely helpful to have some counselling to help you deal with those feelings. You will also be sorting out practical arrangements and any arrangements for your children if you have them. And in the midst of all of that, you will be trying to resolve financial issues, how to divide your property between you, and agree what maintenance payments are appropriate, if any. If you think you and your spouse have already reached an agreement, or you think you will be able to reach an agreement, then that is very positive. It is important that before you do reach an agreement, you each have a complete picture of the other person's financial position. You will need to write down the agreement that you and your partner have reached and then take it to a solicitor who will advise you whether the agreement is reasonable and, if it is, will convert your agreement into a formal court order. You will also need to record your financial position, what assets you both have and how they are held, on a specified form. The document prepared by the solicitor will be considered by a judge, who will also look at the form setting out your financial position. The document prepared by the solicitor will be considered by a judge, who will also look at the form setting out your financial position. The judge will consider whether the agreement that you have reached is one that is appropriate in all of the circumstances before approving its terms. At this point, it becomes a binding court order. Whilst it might be tempting to simply reach an agreement between yourselves and put this into effect without seeking legal advice, there is a very good reason why this is not advisable. You and your spouse each have claims against one another arising from your marriage. The court order will dismiss these claims where it is appropriate to do so. If this does not occur, then those claims remain open, and if your spouse does not remarry, there is a possibility that they could make an application to court for financial provision from you many years in the future. You also want to make sure that the agreement reached is reasonable. If you have not agreed how to divide your assets or what maintenance payments there should be, then there are lots of things you can try to help you reach an agreement. Mediation is a very efficient method of resolving these sorts of disputes. An independent, impartial, and professionally qualified mediator will meet with you both in order to help you resolve areas of disagreement. Another method of resolving disputes is arbitration. This is an alternative to formal court proceedings. You and your spouse agree to appoint an arbitrator who then makes a decision for you. You are both then bound by that decision. If you are not able to agree, then the court will need to decide for you. You will each be required to provide formal financial disclosure to the court. As part of the court process, there will be a court hearing at which a judge will try to help you reach an agreement in a form of court-assisted mediation. However, if that is unsuccessful, there will be a final hearing at which a judge will decide on your behalf. The court has wide-ranging powers and can make a number of orders, including the sale or transfer of property, the payment of a cash lump sum from one party to the other. The court can split any pensions between you and can order one party to make maintenance payments, usually on a monthly basis, to the other party. Knowing your legal rights and obligations will enable you to make good decisions at this very important time.